Hello, and today we're going to be looking at the criminal offence of robbery. The idea behind robbery, it is the idea of theft which is aggravated by force. Now, as with my other videos, you can find an outline of the offence, which is also written on the whiteboard behind me, but I don't think you'll be able to see on my website. And so, let's begin. The offence of robbery can be found in Section 8 of the Theft Act 1968. And as I said before, it's the idea of aggravating theft by the use or the threat of force. So what does this mean, the fact that it's just aggravated theft? Well, it means that the actus reus and the mens rea of robbery comprises the elements of theft. So the actus reus of robbery has 4 elements, and 3 of those elements are the elements of theft: appropriation of property of another. So there's not much to say on these elements because that will be discussed more in my theft video, but we'll just make a few points about appropriation. So the first point is the courts are quite flexible when looking at robbery in terms of appropriation, because in the case of Corcoran and Anderton 1980, what happened is these defendants, they snatched the woman's handbag and they slapped her with the handbag, so there was clear use of force. Now the issue was that even though they tugged the handbag, they essentially left the handbag and ran off. So had they appropriated it? And the court said yes, the mere act of tugging it, they had assumed the right of the owner, and therefore the appropriation had happened. And the second point to make with appropriation is it's viewed as a continuing act. So in the case of, R and Hill 1978, the 2 defendants were arguing that because they used the force after taking the jewellery, after the theft had occurred, this could not be robbery. However, the court said the idea of appropriation is a continuing act. So the mere fact that you're saying that the actual key point of appropriation had happened afterwards, this is not a problem because it's a continuing act. Those are the 2 points I felt the need to share in this video on robbery. Then you have of property of another, which is the general issues we'll look at in the theft video. But the 4th element of robbery is obviously force. Now it's a use or the threat of using force. So now there are, I think, 6 elements, 6 key characteristics of force that we need to be aware of. The firstly is the courts assign the ordinary meaning of force. There is no special definition. And what this means is that the jury are left to decide what is meant by force. And this is made clear in the case of R and Hill 1978, which we already discussed above. The second thing is, it is also clear that a small degree of force, where there's no actual injury, can suffice. That is pretty clear from the case law. And third point is that even though a small degree of force is required and there doesn't need to be any actual injury, we must distinguish force from mere touching. So let's look at an example. In R and Hill 1978, the appellant used force in the sense that they put their hand over the victim's mouth. This was distinguished from touching and it was counted as a use of force. Whereas if we compare this case to DPP and RP 2012, the defendant snatched a cigarette from the victim's hand. Now, there was no additional physical contact, and so the court said this was insufficient for force. This was mere touching. Snatching is not enough. Whereas putting the hand over the victim's mouth, that obviously does count. Then the 4th point is the idea of force, it need not be directed at the victim. It can be directed at a bystander, somebody who's just possessing the item, or even the property itself. So let's have a look at some cases. So in Dawson 1978, the jury decided that jostling the victim in order to pickpocket was capable of force, even though other people were affected by the force more so than the victim. And similarly, now we're looking at force against property, which also counted. So in Smith and Desmond, 1965, 2 defendants, they broke into a premises. They attacked the watchman and the engineer. Now, basically, what they were saying is that even though the force was directed at the watchman and the engineer, not the person who the item belonged to, they could still be convicted of robbery because they had used force even though it wasn't at them. Sorry, that was a case of using force at a third party, not at the property. The case of using force against a property as opposed to the person was in R and Clouden, 1987, where basically the defendant wrenched a basket from the victim's hand, and basically they had attacked the property as opposed to attacking the person. And under the old law, there was a distinction between force used on the person and force used on the property. But this case has made clear that this distinction need not exist anymore. And if the force is used against, the jewelry or the handbag and not the person, it can still be counted as force. So then the fifth key characteristic of force is that it doesn't need to make the victim frightened. It just needs to exist. So in the case of B&R v. DPP 2007, the victim was startled, not frightened. So they tried to argue on that grounds that there wasn't force, as it were, that existed. But the court said no, just the existence of force in its objective sense. By objective, I don't mean the legal meaning of objective, meaning like it was just present force, regardless of how it made the victim feel, is sufficient. And the final key characteristic of force is the fact timing, because it's the idea that the timing of the force, it must be itself or just before the theft takes place. And this will basically depend on when the appropriation takes place and the whole facts of the case in general. So there's no specific rule on that. So then we move on to the mens rea. Now, as with the actus reus, two of the in the actus reus there's three, but in the mens rea there are three elements to the mens rea, and the first two are the mens rea of theft. So firstly, you have dishonesty. Now, there's not much to say here because that will be discussed in the theft video, but a crucial point to make is that basically the dishonesty has to relate to the appropriation, not the force. So in the case of Robinson, 1977, there was no theft since the victim had an honest belief he was entitled to the money, so he wasn't appropriating it. Therefore, there was no theft. You're looking at the idea of dishonesty relating to that as opposed to the violence or the threat of violence. Then you have the second mens rea, which is found in theft, which is an intention to permanently deprive. Now, this is in the case of R and Vinyl 2011. And basically, the crux of the matter in this case, you can read the facts, it's about two youths and they scare off, two youths are riding on a bicycle and the defendants, they shout some abuse and the victims, they run off leaving their bicycles, and then the defendants, we don't know what happens, but the police later on find that they had abandoned the bike not too far away from the crime scene. And so they tried to argue that there was no robbery because they didn't use force to appropriate the bike, and secondly, there was no intention to permanently deprive. Now, the key point here is it says in the judgment that when the allegation is of theft, a later appropriation will suffice, i.e. when there's been abandonment of the bike. But when the allegation is robbery, it will not. So what you need to do there for robbery is you need to make sure that intention to permanently deprive, it exists at the time of appropriation. That's what the case is trying to get at. And the final mens rea of robbery is that the force must be intentional for the purposes of enabling theft. So in a practical sense, what does this mean? Well, it means that the defendant who accidentally uses force while stealing will not commit the offence of robbery because it must be your aim or purpose to use the force as a means of enabling theft. And before we conclude, a final note, there is also another charge which is similar, which is assault with intent to rob. Now, this is different in the sense that you don't actually commit the robbery, you have the intention of robbery, but the actus reus of assault. Thank you for watching, and I hope this helps.